Let me tell you something. This is exclusive, Doctor. I have got the response from the XPress Feeders.
We unanimously decided on that Sri Lanka is the best jurisdiction to file this case.
Is it possible, though, for the express feeders to limit their shipping operations in Sri Lanka?
The Attorney General was held to be liable for breach of fundamental rights.
The former Justice Minister Vijayadasa Rajapaksa told me that out of the 3 members of the expert committee, 2 other members later agreed to file the case in Singapore.
If you don't pay, then it would amount to contempt of court to the Supreme Court of Sri Lanka.
There have been a lot of arguments after the judgment that this judgment cannot be enforced.
The fundamental rights case is a different area. It is not an Admiralty case. It is not a maritime case.
Commission appointed by the Supreme Court is a Judicial Commission, isn't it?
There are 4 parties that were made responsible financially: the owner, the master, operator, and the local agent.
Can that be enforced?
When we are not a party to such a LLMC convention, other courts can make the wrongdoer unlimitedly liable. I should say that all these parties were represented through their respective lawyers. There is no issue. The case was heard ex parte without the respondent.
Good day, everybody. As you all know, the Sri Lankan Supreme Court delivered a landmark judgment on the Express Pearl disaster on the 24th of July, a couple of days ago. So, in that judgment, the Supreme Court ordered the ship owners to pay 1 billion initial compensation. I have to stress this. This is not the final compensation amount. $1 billion as the initial payment of the compensation. And also the Supreme Court appointed a special commission to continue to assess the damage. And I'm here with one of the experts of Admiralty and Maritime and Shipping Law, Dr. Dan Malika Gunasekara. Hi, Doctor. Hello.
Hello. Hi, Saroj. Yeah. Thank you
Doctor,
for
so
connecting
what
with me.
what is your response to? I mean, I just said about one aspect of the judgment. It is a lengthy judgment which goes into 361 pages, and one thing is about the compensation. The other thing is about that the Supreme Court found both state parties as well as non-state parties are liable. So let's start with the amount, the compensation. Can that be enforced? My first question.
Now, first of all, Saroj, I should say that this is a very historic judgment in Sri Lanka. I guess that this is the largest amount that was awarded in a fundamental rights case of this nature in a public interest litigation. And we know that the magnitude of the loss and damage that was caused due to the Express Pearl fire disaster on board the ship. And therefore, the marine environmental damage that caused to the waters and the maritime environment of Sri Lanka is so huge and gigantic. And therefore, considering all the surrounding circumstances, facts, and so forth in the case, it is highly commendable that the Supreme Court of Sri Lanka has awarded such a compensation of that magnitude. And we should first of all extend our heartfelt gratitude to the Supreme Court of Sri Lanka for attending to an area that is new for Sri Lanka with the plastic pollution that occurred in our waters. So when it comes to the quantum of the loss and damage and the compensation so awarded, I should say that the amount is also very large. 1 billion USD, when you convert into Sri Lanka's rupees, it's almost like 300 billion Sri Lankan rupees, which is a huge amount. But however, you may know that with the calculation of the loss and damage that was done by the expert committee, it was proposed to have a compensation of more than 6.3 billion United States dollars, considering the damage and loss that occurred. So, as you said very correctly, this is the initial component of the compensation, and it may extend further because the judgment of the Supreme Court is very clear that this is not the final verdict, and though it is final verdict as to the merits, there may be instance where the Supreme Court could consider further claims that are coming up with regard to this loss and damage.
Because
So
that commission is
one
a
thing
judicial
with the
commission, isn't it?
yes,
Commission appointed by the Supreme Court is a judicial commission, isn't it?
Judicial Commission, yeah, because if you look at the overall effect of the judgment, this judgment is very conclusive in the sense that it covers many aspects, especially how such compensation to be distributed among the various claimants. And that's why a commission was created under the chairmanship of Justice Amarasekara of the Supreme Court to determine on the claims that may come up to the commission and distribute among the various claimants. So since the quantum is so large, now questions gather as to how this compensation can be collected in fact, because in the judgment there are 4 parties that were made responsible financially to compensate this, especially the owner, the master, operator, and the local agent. Now, out of the 4 parties, the 4 parties were jointly and severally made liable in this. So, which means that either they pay jointly together, or if some party is not going to furnish this, then it can be obtained from any of the parties involved. And I should say that all these parties were represented in the Supreme Court through their respective lawyers. And so there is no issue that the case was heard ex parte without the respondents, because all the respondents were there represented by their respective lawyers. Now the question is how the respondents can pay this.
Let me interrupt, Doctor. Yes, there have been a lot of arguments after the judgment that this judgment cannot be enforced. I mean, you remember, we all remember. Even that was one of the arguments by the Attorney General itself, right? Because they went to Singapore. One of the arguments, they had a couple of arguments. One was that it will be difficult to enforce because a judgment by a Sri Lankan court would be difficult to enforce. Is that the case? Would it be difficult to enforce?
We have to distinguish this particular case with other cases. Now we know that there are several cases that are lying in various courts in the world, especially few matters that are being heard in Sri Lanka with respect to private claims. In the commercial high court, in the exercising the Admiralty jurisdiction. Then we have this Supreme Court matter as a public interest litigation in relation to a fundamental rights breach, infringement of fundamental rights. And apart from that, we do have a case in Singapore where the government of Sri Lanka, through the Attorney General, has filed a case for civil compensation in Singapore. And also there is a action lying in London with regard to the limitation of liability of the owners. So this is a huge jumble now. There's a lot of legal jargon. But if you take out all these things, the fundamental rights case in terms of public interest litigation is a different area. It is not a Admiralty case. It is not a maritime case. It is a fundamental rights breach. So the Supreme Court has awarded this compensation and made the responsible parties responsible and liable. In that case, since it's a fundamental rights case, a judgment delivered by the Supreme Court, it is a judgment that can be entered against the responsible parties who have been held so in the judgment. So now they can't move back and say, look here, that there are other cases lying in the other parts of the world, and therefore we are not liable to pay this. Because, if you don't pay, then it would amount to contempt of court. Because contempt of court to the Supreme Court of Sri Lanka, and that the Supreme Court has dealt this matter in a public interest litigation for fundamental rights infringement, as I mentioned. So Supreme Court has held that these parties are liable to pay the compensation, while the three institutions, with two being private persons of state officials, being held liable without any monetary compensation, without any monetary penalty. And as we know, the Attorney General was held to be liable for breach of fundamental rights. This is, I think, one of the
Very
cases
rare
in the
cases,
history
right?
of Sri Lanka.
Yeah, very
Yeah,
rare cases. Yeah.
in Sri Lanka, that the Attorney General was found to be guilty of a breach of fundamental rights.
Now, let me tell you something. This is exclusive, Doctor. I have got the response from the XPress Feeders, the former operator of the company. It says XPress Feeders is extremely disappointed with the judgment from the Supreme Court of Sri Lanka arising from the casualty of the Express Pearl, which ordered that non-state parties involved in the casualty make an initial payment of 1 billion within a year. We are reviewing the substantial 361-page ruling with our legal advisors and insurers and liaising with other relevant stakeholders, including the International Group of Protection and Indemnity Clubs, to best assess our next course of action. In respect of the ongoing legal action related to this incident, we will not commit further at this time. So this is the first ever response. They say they are extremely disappointed and they are assessing the next course of action. What is your response, Doctor?
Now, this particular Express Pearl ship, it had the insurance coverage for marine environmental damage, and that is somewhere, I believe, like it's about 2 to 3 billion or something like that, the insurance cover that was provided by the P&I Club. And according to the P&I Club insurance policy, when there is such a marine environmental damage, they are obliged to pay. But there can be various kinds of legal constraints and concerns that they may have. But end of the day, since I told you that this is a fundamental rights infringement case, they have to honor the decision of the apex court in Sri Lanka. There is no way that they can appeal. So there is a situation of looking at the judgment delivered by the Supreme Court, but as far as I can see, there is no conflict of laws here. Because that this particular case is nothing to do with an admiralty action. This case is nothing to do with a maritime dispute. This case is with regard to infringement of fundamental rights. I always stress this point, to distinguish this matter with a maritime claim. In a maritime claim, of course, they can fight for all these limitations of liabilities, and that the claims are not in order of the P&I Club's undertaking and like that. So it is a matter that if the responsible parties fail to furnish the compensation so provided by the apex court in Sri Lanka, that would amount to contempt of court.
But obviously that would, it is to do with then the local agent. than the ship owners and the insurers, because obviously ship owners and the insurers are not Sri Lankans. So it will mainly affect the local agent, isn't it? So is it possible, though, for the express feeders to limit their shipping operations in Sri Lanka, and also it is possible for them to raise insurance premiums, isn't it?
Now, this question has been posed by various people in the shipping trade. As long as the shipping practicalities are involved in shipping business, the Colombo port service express feeders as one of the leading feeder operators obtaining the services of the port of Colombo. And there are so many other feed operators, large scale and medium scale and small scale. There are these companies are competing with each other. Shipping business is to say it's a competition. It's competition between various parties involved in shipping. Now, the port of Colombo is a very important port as long as the South Indian Ocean is concerned. It is a strategic port located in the South Indian region. And Colombo port handles over 75 to 80% of transshipment cargo that are coming from the subcontinent. So Colombo port is very important for any line. Any shipping line that operates feeder or containerized services, very large container operators and everything, inclusively, they operate their vessels and fleets to Port of Colombo. So if somebody goes out of the Port of Colombo rejecting to report call to Port of Colombo, then there are other feed operators and main lines who will compete and take out the business. So this is a question of business, nothing else. So in case the judgment extend to I'm telling in case if the judgment extend to the imposition of its ruling to the operator in this case, and the operator decides to prevent from using the Port of Colombo services, there are so many other competing parties that would take out the business. And it's a huge business. And in terms of economics, losing of this kind of a business would impact such an operator or the shipping company hugely. So I don't think that this would be a reason for any operator, the operator in this particular matter, to avoid using the Port of Colombo, because they simply cannot operate without the Port of Colombo. And, this is something that the previous government even could have thought of. At the time when this Express Pearl happened, they could have thought of bringing in various kinds of actions in relation to this particular thing. When it comes to insurance component, this is not something to do with the insurance premium that the ships have to bear increasingly. Yeah, like for example, if there's a war during our wartime, yes, the insurance premium was high because the ship posed a huge risk in coming to Port of Colombo. But here in this matter, it is different. It is not like that. It is not where that the shipping line or the operator should see that our insurance policy, our insurance premium would go up. This is as correctly held by the Supreme Court, the responsible parties are liable for committing the loss and damage caused to the marine environment of Sri Lanka.
Doctor, you were a member of the three-member committee appointed by the Sri Lankan government to look into the possibilities of legal action against the compensation claim against the shipowners, Pearl Express Feeders. And then the committee recommended to take legal action in Sri Lanka. But irrespective of your advice, we all know now the Attorney General Department, with the approval of the Cabinet of Ministers. That goes up to the former President Ranil Wickremesinghe, because he was the president, he was the head of the cabinet, and cabinet approved. With the approval of the cabinet, they went into file the case in Singapore. What do you think about that now?
No, it's a very good point that you raised, Saroj, because uh, this particular legal expert committee was appointed by the Marine Environment Protection Authority, MEPA, in order to determine the best jurisdiction to file the civil action against the perpetrators, against the wrongdoers. And initially, this committee consisted of myself, Mr. Chandrakajaya Sundara, President's Counsel, and Mr. Ronald Pereira, President's Counsel. Three of us were appointed by MEPA because MEPA is the coastal state controller of Sri Lanka. So they are the real clients for the Attorney General in this particular matter. So they appointed three of us in order to determine the jurisdiction. Then we unanimously decided, based on the various maritime laws that are prevalent in Sri Lanka and applicable, especially considering the Admiralty Jurisdiction Act, we have seen that whenever there is a damage caused by a ship, the damage done by a ship, then the Admiralty High Court based in Colombo, which is now the Commercial High Court, has the power to determine an action of this nature, and therefore our Sri Lankan court had jurisdiction. And we unanimously decided on that. We tendered our written signed document to our client, the MEPA, that Sri Lanka is the best jurisdiction to file this case. Because this decision was arrived by looking at various laws that are applicable in Sri Lanka. As I told you, the Admiralty Jurisdiction Act. And also the fact that Sri Lanka is a party to the International Convention on Limitation for Maritime Claims 1976 and its protocol of 1996. Now, when we are not a party to such a LLMC convention, our courts can make the wrongdoer unlimitedly liable for this. And it was very advantageous for us, territorially as well as legally advantageous for Sri Lanka to hear and determine this case. But however, when a meeting was called by the Ministry of Justice in order to discuss this, the Honorable Attorney General mentioned that finally, after hearing all the parties, including the expert committee, decided to go to Singapore. So this was in fact against the expert committee report. And throughout this particular incident of Express Pearl, I can remember from day one I had been voicing about this incident. I was talking about the legalities, the illegalities, the law relating law applicable to these kinds of situations. And, I should say that they did not listen to the experts in this country. Somewhat, I remember even in the parliament, the government at that time, a particular minister mentioned that we do not have maritime law specialists in this country. Come on, because I am a German scholar who has done my PhD in maritime law in University of Hamburg, and I practice in Sri Lanka in the maritime sector. And we do have the particular experts in the area. I was a dean of the Maritime University in Sri Lanka. I was executive director of Ceylon Shipping Corporation, the national carrier. So how can somebody say that we do not have an expert in maritime law? This is unacceptable. This is unreasonable on the part of the state to make such a comment that we do not have a maritime expert. Colombo is eager to become a maritime hub. We have to use our expertise. We do have people who have specialized in various areas of maritime. I have specialized in the law sector. Then there are people I know who have specialized in different areas of business, economics, and science, and everything when it comes to maritime. We have a huge think tank when it comes to maritime affairs. We should have used that think tank, but the then government, they did not take much use of these
But on the
experts.
contrary, Doctor, on the contrary, glad that you mentioned about the Justice Minister, the former Justice Minister Vijayadasa Rajapaksa. I met him on this particular case, and he told me that apart from you, out of the three members of the expert committee, two other members later agreed to file the case in Singapore. It was only you that objected or didn't change your opinion.
That, of course, officially I don't know, because I checked with one of the persons. I don't want to mention his name. I checked with one of the President's Counsel who practices with me in Admiralty, whether he committed himself consenting to this, going to Singapore, and he categorically mentioned no, he did not. He did not. So I don't agree to such a comment that that it was only me who objected going to Singapore. So I'm sure that the other person also objected to going to Singapore. We were not in agreement. So I don't find that it's very authoritative statement to make it, because we were all three officially appointed to do this. To give the recommendation. So why didn't ask from me? You mentioned the Justice Minister. Justice Minister didn't personally ask me at all whether I would consent or not consent going to Singapore. The only meeting that was convened, as I mentioned earlier, together with the state officials, where we categorically mentioned that we have to file this case in Sri Lanka. If all the legal authorities support the filing of the matter in Sri Lanka, not going to Singapore. So out of that meeting, I was not consulted at all.
I have to mention this also. I spoke to Mr. Sanjay Rajaratnam, the former Attorney General, because I wanted to get his response as well. Because if there is a story, if there are two sides of the story, I wanted to get his opinion, his response. He said he very politely he said he refused to make any comment. So why on earth? Why did they, the Attorney General as well as the team, Attorney General Department's team, despite all these objections, decided? We now know that even the Supreme Court upheld our conviction that it was a very wrong decision to go and file the case in Singapore.
The main point that they raised was that the shipping company has its main, the shipping company is Singapore. That was the main concern. But we know that the shipping company by that time was already bankrupt. Because in shipping business, every ship is made out of a single company. Every ship has a single company, what we call the single ownership shipping company. And already by that time, that particular shipping company, EORS company, was already bankrupt. It had the only asset that it had was this particular express per ship, and that was lost. So there was no tangible asset that rests in Singapore. So that was the main reason that they indicated. The reason that they are going to Singapore is that the shipping company is based in Singapore. Now, come on, what we said was, okay, if you want to have the compensation, then you should file the action in London, because the P&I insurance is based in London. So therefore, go to London and file the case. That is much better forum than going to Singapore. Because in a normal road accident case, we know that if when the motorist is liable for an accident, we file the case against the motorist as well as the insurance company. But in a shipping case, there is what we call direct action, where the insurance company can be directly sued, right? It's called the direct action. But so in that case, the London going to London and filing the case against the P&I is a much better option than going to Singapore, where the company itself is bankrupt. So there is no justification that can be found in going to Singapore.
Now that the Sri Lankan Supreme Court has delivered its verdict, Doctor, do you think it is feasible for the state? I understand you very particularly, I mean, very well explained that these are two different cases. What happened in Sri Lanka was not an Admiralty case, not a maritime case, but still, is it feasible for the Sri Lankan state to pursue the both cases, the appeal in the United Kingdom as well as their civil lawsuit in Singapore?
Of course, it is possible. It is possible. There is no bar preventing. But now we have gone to Singapore. The Singapore case has been barred by the English court, because what they say is until the limitation proceedings are over, then to suspend the proceedings in Singapore. Now the Singapore case has been barred. We told them not to go to Singapore. We asked them to do in Sri Lanka. Suppose that the case was filed in Sri Lanka, it wouldn't have been barred like that, because what we have in conflict of laws in the legal theory is that the forum convenience. The Sri Lankan forum is the convenient forum. And in order to bar Sri Lankan action, then we have seized our action first. So therefore, when the action is seized first, then our action remains. It can persist. So now we are in a situation that the civil claim, what we have filed in Singapore, has been barred by the English court for the moment until the limitation proceedings are heard. So this is very, very disadvantage for us. And one more thing I want to emphasize in this judgment, now in the Supreme Court, it held that the master, owner, operator, and the local agent are liable. Now, why come the master? Because there is very important reason. Saroj, you may remember, because I appeared in this case for one of the respondents, and I enlightened the Supreme Court on the various international laws that are prevalent in the maritime sector. And a very important doctrine that I took up there is what we call the prudent seamanship. Prudent seamanship is that the master has the overriding authority to take decisions on board. He should exercise his prudent seamanship in sailing. Now, in this case, this is a ship that was refused by two ports before it came to Colombo. It was refused in Hamad. It was refused in India, right? So before it came to Sri Lanka, the master should have applied his prudent seamanship, whether to throw away this particular leaking container out, or to, if it cannot be thrown away, they can call for international salvors in mid-sea and rework the containers. So that was an option. So prudent seamanship comes into effect here. These seamen, all these maritime professionals are well educated.
Thank you, Dr. Dan Malika Gunasekara, for joining us and explaining the situation to our fellow Sri Lankans. And thank you also for being with us. And I hope to continue this dialogue, this conversation, especially explaining the Supreme Court ruling and the implications, as well as the future developments with regard to the XPress disaster. Thank you very much. Have a good day.